Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. You guys remember when the Bruen case came out and we really thought like the sun had risen again and everything was going to be cool? Yeah, so do I. And then, of course, we just saw bill after bill after bill coming out of these crazy civilian disarmament states where they essentially called them Bruen response bills. Perhaps the most egregious offender was the state of New York, in particular Governor Kathy Hochul. And as you know, because they were the state that actually had been smacked down by the United States Supreme Court, when they realized that they were going to have to issue concealed carry licenses to lawful and responsible residents of that state, well, then they just decided they would turn their entire state into a gun-free zone. Well, that case went up to the Second Circuit, and the Second Circuit thought it was A-OK, went to the United States Supreme Court. They went, no, it's not, sent it back down to the Second Circuit, and guess what? They still said, yeah, it is, it's totally fine. Today, we're going to take a look at an amicus brief. It's a really good amicus brief because it begs a question that it's going to be the subject of today's video. So today, let's spend a few minutes and let's talk about the brief that asks if the Supreme Court has a backbone. Okay, America, here's the case we're talking about. It's called Antonyuk v. James. Have we talked about this case before? Yes, we have. Have other people out here in the YouTuberverse talked about this case? Yes, they have. Why is it? Because the case has been kicking around for quite some time. Again, you heard the history at the very beginning of the video. This is a challenge to large chunks of New York's Concealed Carry Improvement Act. Of course, the lower court found it was fine. The Second Circuit found it was fine. It went up to the Supreme Court on review, got GVR'd, granted, vacated, and remanded by the Supreme Court back down to the Second Circuit pursuant to Rahimi. Second Circuit took a look at Rahimi and went, no, it's still perfectly okay. And so now we are back up to the United States Supreme Court again. This is an amicus brief, and the parties to this amicus brief are Second Amendment Law Center, California Rifle and Pistol Association, Delaware State Sportsmen's Association, Hawaii Rifle Association, Gun Owners of California, Federal Firearms Licensees of Illinois, Second Amendment Defense and Education Coalition, and Operation Blazing Sword Pink Pistols. And I want to thank Aaron over at Operation Blazing Sword for actually tipping us off on this brief and sending it to us. Now, I said at the very outset that this brief really challenges the Supreme Court and asks them, hey, what are you going to do about it? I mean, do you guys have a backbone? Do you have a pair of you-know-what? Or are you going to allow these lower courts, which the minute Bruen came out, they were looking for ways around it. And then, of course, once one state came up with it, then you see that permeate. But then someone puts an extra twist on it, and they come up with a more, what we'll call creative or ridiculous argument, and then all of a sudden you see that permeate all the way throughout these states. And it goes on and on and on. And now you're seeing courts where on the first go around on an assault weapon ban, they said, well, yeah, the Second Amendment applies here, but when we do this interest balancing test, well, society wins and the individual, you're out. Now they come back on Bruen and what do they say? Well, the Second Amendment doesn't even apply at all. Setting up the challenge to the United States Supreme Court here, the Amicus Party points out the long and terrible history of this case, in particular, how Governor Hochul and the state legislature in New York just absolutely crapped their pants and responded to the Bruen opinion. As the Amici Party point out, it effectively limits carry in New York to some streets and sidewalks. So incredibly, New Yorkers with CCW permits now have less of a right to carry than they did before Bruen, with many more locations now off limits as supposedly sensitive. Which then, of course, begs this question, and New York is not alone, is these courts that are intentionally thumbing their nose at the United States Supreme Court, intentionally basically throwing them the middle finger. And so the Amicus Party here asks, thus the question presented here is really this. Did this court mean what it said in Bruen? And if it did, will the court allow the very same state that nullified the right to carry through its unconstitutional good cause requirement to achieve the same result through other equally suspect methods? Listen, I remember when Bruen came out. You all remember when Bruen came out. It seemed like that was really, really going to just clean it up forever. But as the Amicus Party points out here, it is unfortunate things have come to this. In a healthy court system, this court's intervention would not be needed again so soon after Bruen was decided to vindicate the very right it recognized in that case. Now, of course, the Amicus Party is quick to point out that, there has been other historical analogs of where these lower jurisdictions decided, well, we're just not going to follow what the Supreme Court or what the law of the land is. It literally becomes an outright mutiny on the rule of law and the dangers that comes with it. As the Amicus Party points out, American history teaches us, however, that when state and local governments are forced to comply with Supreme Court rulings they disfavor, provincial defiance must be promptly quashed before it becomes that sort of ingrained custom, habit, or practice that grew out of Plessy v. Ferguson. Plessy v. Ferguson, of course, was the case that held separate was equal. That was later overturned by Bruen v. Board of Education, which the Amicus Party wisely points out. Like the massive resistance that sprang up in response to this court's decision in Bruen v. Board of Education, see also Cooper v. Aaron, a new massive resistance has been declared in the states that should have changed their public carry practices in light of Bruen. Okay, and I know what a lot of us always say when you see a case like this case that goes up to the Second Circuit and they say it's totally fine, goes to the United States Supreme Court, gets GVR, they say, no, you got it wrong, because that's what a GVR basically says. You got it wrong, we're sending it back, we're going to send the case that we just decided back with it, and you guys try to do this thing all over consistent with what this case says. And then the Second Circuit goes, it's still good. That's why we're back in front of the United States Supreme Court again. How does that happen? Well, you and I both know how it happens. The Amicus Party here had the guts to put it on paper. Instead, it seems clear that the result was predetermined. And only this court's intervention will bring order to courts like the Second Circuit that are hostile to the Second Amendment and are in open rebellion over Bruen. Amici write because certiorari is necessary to quash this growing massive resistance to Bruen, both its analytical underpinnings and what it means for many modern gun control laws. Indeed, to further tolerate this resistance invites the same constitutional anarchy that prevailed between Plessy and Bruen. Now, the Amicus Party does acknowledge that there probably is a historical analog for some sensitive places. And they even acknowledge, when you take a look at the language of Rahimi, that by analogy, you might be able to expand that to a few other sensitive places. But it does not mean that you get to basically call your entire state a sensitive place. As they put it, to be sure, there may be a few truly sensitive places where the right to carry has historically been restricted. For example, legislative assemblies, polling places, and courthouses. These are sensitive places where arms carrying could be prohibited consistent with the Second Amendment. Courts can even use analogies to those historical regulations to determine that modern regulations prohibiting the carrying of firearms in new and analogous sensitive places are constitutionally permissible. Okay, so they're conceding all of that, but then they very wisely point out, but the government may not simply designate large swaths of public space as sensitive just because people gather there. And in summarizing why this case needs to be accepted, not just for the people of New York, but for the entire rule of law, for the entire structure of our Article 3 branch of government, where the Supreme Court shockingly reigns supreme, the Amicus Party wisely points out, the Second Circuit's Antonyuk ruling deliberately distorts Bruen's test beyond recognition to a degree that requires this court's immediate corrective action. The Second Circuit cited with approval a law review article that was extremely critical of Bruen, and it ultimately followed the article's advice for narrowing the Bruen analysis to circumscribe the right to carry. That's right, the Second Circuit actually relied on a controversial law review article rather than relying on case law, statutes, and constitutional interpretation. Okay, the case once again is Antonyuk v. James. We'll link it up down below so that you can geek out on it for yourself. We'll put links down there for all the amicus parties. Thanks to Aaron over at Operation Blazing Sword for sending us this memorandum. By the way, the authors of this memorandum include Anna Barvier and Costas Moros, which of course reminds me that if you're not following Costas Moros on X, you should. That's his handle right there. Check him out. Now, listen, if you got any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is down in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, all of that information is down there in the description box. And then finally, and most importantly, America, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.